folks, and I see that Representative Newberry is here. 7518, it's an act related to the Open Meetings Act. It requires that all closed meetings be recorded. Welcome.
Thank you, Mr. Chairman. I'll be brief because I have a constituent here, Mr. Clifford, who I would ask you to call after me. This legislation arose from discussions I had with him after an incident that he'll elaborate upon. But basically, the issue is this. If there's a potential Open Meetings Act violation, the process is you apply first or you file a complaint at the Attorney General's office, and then they have certain procedures they follow to determine whether or not they're going to prosecute or investigate it. For separation of powers issues and other issues, we're not in the business of trying to tell the AG how to do their job, and that's not what we're trying to do here. The problem is if the suggestion is that a board, a council, a committee, anything that's subject to our Open Meetings Act laws goes into executive session, which they have the right to do and the necessity to do in frequent cases. If the accusation is that they're committing an Open Meetings Act violation by abusing the executive session protocol, how do you prove that? So what we came up with was the idea of asking for audio recordings. They're not considered public records. They're not subject to, APA requests. However, if somebody wants to file what they believe is a justified complaint, it gives the Attorney General's office, if they wish, more evidence of what transpired at the meeting. That's the substance of this bill. I'm happy to take any questions, but otherwise I would turn it over.
Okay, any questions of the sponsor? You want to call up your constituent?
Thank you.
Welcome, Michael.
Good evening, and thank you for allowing me the opportunity to testify on behalf of this bill. I thought the best way to explain what the shortcomings of the current law is and why this particular piece of legislation is necessary would be to relate to you my own experience in filing an Open Meetings Act violation complaint with the Attorney General. I've provided you with a handout that gives a synopsis of the situation that occurred. Basically, we had a board in town that was charged with overseeing the renovation of 2 public buildings with bond money that had been approved for specific purposes. The configuration of the buildings was outlined to the voters before the bond was approved. They met, they had 23 meetings prior to my attending their first meeting on August 9th. And it's the type of little committee that nobody bothers to go to, the meetings. But having heard some rumor that they were not designing a building that was in compliance with the bond language requirements, I decided to go to the meeting. So I went to the meeting on August 9th, and I heard some disturbing information. I shared that at the next council meeting, and the people were not happy that that information that I had heard at the meeting was discussed. And as a result, coincidentally, from that point on, basically, they held all their meetings in closed session and conducted it under the pretense of, my opinion is, the pretense of discussing potential litigation. I filed a complaint with the Attorney General on February of 2018, and unfortunately, on August 21st, 2018, the Attorney General ruled that there was no violation. And what irritated me about the decision, and I'm sure you're thinking, okay, sour grapes, he didn't get the decision he was looking for. It's much more than that. The pertinent sentence in the decision says, quote, "In sum, based on our in-camera review of the executive session minutes, we found no violation," period. Well, the executive session minutes were draft minutes. They were not approved minutes by the committee. They were not written by the secretary of the committee. They were written by the chair of the committee, and they were only handed in and submitted to the town clerk after I had email exchanges for almost a month between the town administrator, the town clerk, the town solicitor, and the committee chair, pushing to get those closed session minutes submitted in accordance with the state law to the town clerk. I think I found it disheartening to believe that you could possibly make a rational decision as to whether or not there was a violation based solely on what one group writes in the minutes. At the point where I had harassed them basically into submitting the minutes, I think it was common knowledge that there was a complaint about the Open Meetings Act that was going to follow shortly. So you'd have to be a complete imbecile not to write something in the minutes about potential litigation to cover yourself. The first attempt by the chair to submit minutes in compliance, he attempted to hand in a sheet of paper that said the date of the meeting of the closed session, what time they went in and what time they came out, period. The town clerk refused to accept them. I handed in, on this list that I provided you, is a bullet list of all of the concerns and in particularly unique situations and circumstances that I believe should warrant something more than just a simple review of written minutes. Anybody can write anything on a scrap of paper. That doesn't mean that's what occurred. So I provided in my complaint evidence to support every single statement that's on this sheet. I gave the minutes of the meeting, the charge of the committee, the town charter that outlined what advisory committees were supposed to be doing. I provided them with tape recordings of the current open session meetings and what was discussed there. There was no business about the design of the building or anything dealing with renovating that building of relevance and significant nature that was ever discussed in open session once I started going to the meetings. On the second page of that handout, I gave you a breakdown of the meetings that occurred after August 9th. And you'll see that of the meetings that were occurred between August 9th and January 18th, which was the last meeting they had before they presented their recommendations to the town council, the open session portion of the meeting on October 5th lasted 4 minutes, on October 17th lasted 7, on November 9th lasted 5 minutes, December 13th 2 minutes, and January 18th 2 minutes. All the rest of the time, well over an hour at each meeting, was spent in closed session with the architect present during 4 of those 5 meetings. No attorney was ever present in the meeting. It just goes on, and you can read the litany of issues in there. They also had an asbestos abatement specialist join them on one of those evenings. And personally, I think there ought to be a disclaimer and an exemption for meeting with an asbestos person in closed session. That in itself is alarming, that you're discussing asbestos in 2 public buildings in closed session. I can't understand how that isn't some type of violation of an OSHA law or something. So anyway, you'll see that they spent an hour, close to an hour at each meeting in closed session, and yet miraculously presented a plan for the redevelopment and the renovation of those 2 buildings with very little time. The August 9th meeting was the first meeting that they ever had an architect with them, working with them, and he presented his plans to them, his schematics and basic concepts. But the 23 meetings before, they had not been working with an architect. So this was a conceptual plan. It wasn't to define exactly the specifics and the blueprints for the buildings. It was to come up with a conceptual plan. So I'm hoping that by presenting you with this list of concerns, of issues that took place that still, and even though these circumstances were present, the decision was made based solely on what was written in the minutes. And I'm hoping that that disturbs you as much as it disturbed me. I don't think any rational person with any combination of these circumstances would think it was appropriate to judge whether or not closed session exemptions were respected or not based on a set of simple draft minutes that had never been approved by any board. So I think that about sums it up. Thank you very much.
Thank you. Thank you for your testimony. Any questions? Hearing none. John Marion?
Good evening, and thank you. I just want to say that Common Cause supports this bill. And note that there are several public bodies that voluntarily record their executive sessions, and I've seen complaints that have succeeded and failed to the Attorney General, where the Attorney General's office has been able to review the tape. So Mr. Clifford is absolutely right. If the Attorney General has a tape to review, it makes it much easier than just relying on the minutes and any affidavits provided by members of the public body. And really, there's virtually no cost. They're not asking for video recording, they're simply asking for an audio recording. So this, I think, makes all the sense in the world, and would, we suspect that there are many public bodies who go into executive session for reasons that aren't authorized under the Open Meetings Act. And this would allow the Attorney General to do a good job adjudicating those complaints. Thank you.
Thank you, John. Any questions? Hearing none. Steve Brown, I don't see him here, so, oh, here he is.
That's right. The ACLU also strongly supports this legislation. You've heard all the reasons for it, and we agree with all of them, and we hope you'll give it favorable consideration. Thank you.
Well, thank you, Steve. And Randall Rose?
Thank you, Madam Chair, and, well, I would say members of the committee. Well, Representative Knight is here. Madam Chair and members of the committee, yeah, thank you. Yes. I'm also in support of this bill. I think it's, thank you. I think it's, as has been said, it's no cost. It has no burden whatsoever to the bodies that are following the Open Meetings Act, but when bodies abuse the Open Meetings Act, which a lot of people around Rhode Island are upset about, this makes it easier to get some accountability. My only real point about this bill is just an obvious one. It says that the meeting shall be recorded by audio tape. There's no provision for how long the audio tape is retained. There has to be something in there for how long the audio tape is retained. I would say that it's worth adding a line that the audio recording should be given to the Secretary of State's office and the Attorney General and retained by them, just to make sure there are no shenanigans. So that would be the natural way to do it. Thank you.
Thank you, Randall. And that concludes testimony on House Bill 7518.